Okay, we had a little technical difficulties. We're back on the record again. Today is March the 13th, 2025. The time is now approximately 9:08 a.m. We're here today for the application for a full drink liquor license for TWT Enterprises LLC, doing business as the Pepper Lounge. TWT Entertainment, LLC, doing business as the Pepper Lounge, to be located at 2005 Locust Street, St. Louis, Missouri. We have present today Mrs.
Alexa Thomas.
Alexa Thomas. Are you the only member of this LLC?
Yes.
According to the record, the paperwork indicate that Ms. Thomas is the sole member of this LLC. For the record, I want to go ahead and I want to add some things. First, I want to put a certified copy, excuse me, you have one more minute. For the record, my name is Gwendolyn Cherry Sims. I'm the Liquor Control Supervisor acting on behalf of Mr. Miles McDonald, the Excise Commissioner, in his absence. I have in the room today, assisting me is Mrs. Mildred Bell Givens, the Executive Secretary to my immediate left. I have a Liquor Control Officer, Ms. Anitra Williams, who was the responsible person to investigate the validity of signatures submitted by your company. For the record, I would like to enter some exhibits. At this time, I want to enter a certified copy of Ordinance 71819 for the City of St. Louis Liquor Code. At the same time, I would like to enter the file belonging to the applicant that's held by the Excise Exhibit 2. As you know, the criteria for a liquor license is that the applicant, the burden of proof is on the applicant on initial liquor license application. And according to the ordinance itself, a burden of proof, the applicant have to obtain two simple majorities: a majority of property owners within the 350-foot radius and a majority of occupant tenants within the 350 feet radius. Do you have any objections currently to any objections to Excise Exhibit 1, the certified copy of the ordinance, Excise Exhibit 2, your file being entered on the record?
No.
Okay. At this time, what I want to do is, because we want to establish if you have met the burden of proof for a simple majority of property owners and occupant tenants. Ms. Williams, would you raise your right hand? I'm asking, would you report the findings and was the investigation conducted during the course of your duties?
Yes, sir.
Would you give your report for the occupant tenant category?
Tenant occupant category, within the radius were 40. Of the 40, the majority was 21%. Of the 21%, the only authentic signatures that you had were 9 signatures that were authentic. So you were under the majority by 12.
Can I ask you what makes them not authentic?
Can you guys speak up, please?
Can I ask you what?
Hold on for a minute. We're going to yield the record and we'll address that.
Okay.
Okay. Just hold up. I'm going to ask you to give your rendering for the property owner category.
My rendering for the property owners within the radius were 51. Of the 51, the majority was 27. Of that 27%, you only had 6 authentic signatures, which made you 21 under the majority.
Okay. Basically, the liquor control officer found that the applicant was potentially 21 signatures short for the property owner category and a total of, under the occupant tenant category, possibly 12. What I'm going to do is I'm going to yield the record at this time, because you have a right to observe the signatures and to see why those signatures were not counted. However, prior to this hearing, you were given an opportunity to come into our office and review the spreadsheet. At no time did you come into the office to review the spreadsheet?
Like when I turned in the signatures?
When you turned in the signatures, you spoke with Mrs. Williams several times, and she told you that you could come into the office to review the spreadsheet. However, that did not happen. What I'm going to do at this time is I'm going to yield the record, allow you to review why a signature was not counted. Then any objections, we'll take those objections. If we can answer them at this time, we will. If we cannot, we will put them in the decision to follow with the findings. At this time, I ask that the record be yielded. Okay. This is a copy of the property owner category. Okay, we're here for the TWT entertainment hearing. I yield the record for a brief moment, and we were going over the findings of Mrs. Williams regarding the property owner category. I allowed time for Mrs. Thomas to review the summary of investigation to see if she had any objections. Some of the things that we discussed was basically the radius itself. And she briefly mentioned that she kind of got a little bit confused because of the 3 a.m. that they also applied for. However, with the liquor license, the primary license is the full drink license, and you have to obtain 2 simple majorities in the radius of 350-foot circle before any signatures would be considered for the 3 a.m. petition. If you don't obtain the signatures in the 350-foot radius, that license the burden of proof for the applicant failed to obtain. Some of the reasons what I see that of the signatures which made you 21 property owners under was that the radius was exceeded the boundaries of what you were asked for. The addresses was outside of the radius. And by those addresses being outside of the radius, we can't count them. Therefore, based upon the findings, do you understand?
Yes.
Do you have any objections?
No.
Okay. I'm going to ask you, do you understand the occupant tenant category? Basically that you failed to obtain a simple majority of occupant tenants. You're 12 short. Do you accept the rendering that is here?
I'm not sure, because this 2106 Locust is in that radius, correct?
So I guess, so these addresses that are in the 3 a.m. license do not count because we need to get the 130 first.
You have to get the 130 first. Your primary license, you cannot operate a liquor business unless you have a primary license. A 3 a.m. is a secondary license. So you have to secure the burden of proof for the 130 license of 2 simple majorities.
I was never informed that when we initially applied. So that's why I had zero idea.
Were you given 2 sets of petitions?
Yes.
Were you given 2 sets of plats?
Yes.
Okay. And I'm not sure because I wasn't the one who spoke to you. But according to file, we gave you some time to come in. They indicated that they called you and spoke to you, left several messages on 225, called and left a message regarding it, letting you know that you were short signatures and explaining that to you. Also, they called back and informed you on 3/7, you brought in additional signatures. Again, on 3/7, you turned in some additional signatures. They asked if you wanted to see the spreadsheet, quote unquote, indicating that you did not want to see the spreadsheet.
That was not asked. I turned in the signatures and They did not ask me if I wanted to see the spreadsheet.
However, okay, however, based upon the findings of the liquor control officer, I'm gonna put it on the record once again. Based upon the findings, a total of property owners in the radius was 51, a majority would have been a 27, at which time the applicant submitted 6 valid signatures, which is 21 under the majority necessary for a successful application. Based upon the occupant tenant category, it was 40 occupant tenants in the radius, 21 would be a majority, at which time the applicant submitted 9, which is 12 under a majority. At this time, based upon the signatures being submitted, based upon the investigation conducted by Liquor Control Office Anitra Williams, I hereby deny the issuance of the full drink liquor license for Pepper Lounge located at 2005 Locust Street, with the understanding that any decision that I make here today can be appealed through circuit court. And by the application being denied here under the ordinance, the applicant cannot make a new application for 60 days.
Can I ask for an extension?
No, ma'am, this is the hearing at this time. We can't extend it. This is the order of today. For this hearing, it is being denied based upon you failing to obtain 2 simple majorities. May I, yes, sir, Mr. Franklin. No, I'm gonna put this on the record.
So I'm Robert Franklin. I support businesses in St. Louis. And I want to ask a question on the record. How can a business be in business for 15 plus years with no liquor problems with the liquor license whatsoever? And then all of a sudden, some partners fell off, and then we have to go through the whole process all over again to be denied. And then on all the signatures that was obtained was all the people that reached 100% because I helped support it. And I just don't understand, like, St. Louis, like their whole process on the liquor license, because something has to change, because it ain't just me, it's a lot of voices behind me that I already got petitions on, and we will fight this, because this business, Pepper Lounge, been around forever. And guess what? Everybody that I know that owns property over there, if Pepper Lounge go down, guess what? The property value go down. And I don't understand how everybody in your office has an opinion, a bad opinion. Not everybody, but everybody that we spoke with had an opinion about Pepper Lounge not getting a liquor license before this hearing even started. So obviously, something else is going on here. And I mean, it needs to get down to the bottom of it. I know you in charge of your office. Public safety is overlooking this hearing and like on record and everything. So can you answer that on record? Why? How?
First of all, we cannot regulate another person's office about what's going on, but the burden of proof has not been met here today. Any applicant who makes an application and they're making an application for a standard liquor license are required to obtain 2 simple majorities. And as of today, TWT Entertainment LLC has failed to meet the burden of proof.
So this is what I'm saying. So
We're not in a debate, Mr. Franklin. I have given you a time to speak. Therefore, I'm going to end that conversation because I cannot regulate that. Mr. Weiss, how may we help you?
Did the petitioner get the majority of signatures within a 500-foot radius?
At this time, based upon them not obtaining the signatures in a 350-foot radius for the primary license, we don't proceed to the 3 a.m. One must secure 2 simple majorities in the 350-foot radius to be considered for the 3 a.m.
As I remember, it's 2 different applications, one
Yes,
for
sir.
1 or regular and 1 for 3.
Yes, sir, you're correct. Okay, based upon our finding of today, I hereby conclude this hearing. Thank you. Good morning, we're back on the record. The time is 9:40 a.m. We're running a little bit behind from the previous hearing. We're here today for the application hearing for a full drink Sunday liquor license for Oak Group STL LLC, doing business as Oak Restaurant located at 3182 through 84 Morganford Road. We have the applicant here today, Miss Asia, and I don't want to mess your last name up,
It's Isla Klavnikovich.
Ms. Kovich. And we have also Mr. Ricky
Marquette.
Borick, who are managing members within the LLC, and Mr. Joe Kelly, the agent. What I'm gonna do is, this application was filed on November the 5th, 2025, indicating that the two persons appearing here today are the shareholders. I want to enter on the record Excise Exhibit 1, which is a certified copy of our ordinance for the rules and regulations that are governing this hearing today.
Okay.
Also, for Excise Exhibit 2, I want to enter the file belonging to Oak Restaurant. And at this time, I want to, for Ms. Williams, who was the agent that was assigned the task of reviewing the
Sure.
signatures for the validity of signatures. Ms. Williams, would you just raise your right hand? Did you perform this investigation in the course of your duties, and
Yes.
would you give your report for property owners at this time?
My report for the property owners, within the radius, there were 85. Of the 85, the majority was 44. Of the 44, you had a total of 44 authentic signatures, so you were right at majority.
Do you have any objections to the rendering of Mrs. Williams' report for property owners?
No, ma'am.
Ms. Williams, will you give your report for occupant tenant, please?
For occupant tenants, within the radius, there were 36. Of the 36, the majority was 19. You also had 19 total authentic signatures, so you were right at majority for your occupant tenants.
Do you have any objections to Mrs. Williams' findings for occupant tenant?
No, ma'am.
Okay.
I apologize.
We did a research to ensure that this LLC, all taxes were paid. That was rendered on the record. We also looked to see if there were any nuisance complaints for this particular location. We did not find any nuisance complaints for this particular location. Do you have any questions of me at this time?
No, ma'am. No, ma'am.
Okay. Based upon a preponderance of evidence that two simple majorities have been met today, and no one speaking in protest to the issues of this liquor license, I hereby approve the liquor license pending the production of all other requirements.
Thank you.
Thank you.
Okay, at this time, I conclude this hearing.
Thank you guys so much.
9:53 a.m. We're here for the application hearing for a full drink Sunday and Summer Garden for Lemonade LLC, doing business as Lost Patio MX Casino, located at 3919 West Pine. We have today the 100% shareholder, Mr. Francisco Lemon. And we also have the managing officer, Ms. Cassandra Lamont, present. Based upon this being a small business criteria liquor license, with the understanding that the nuisance property database was checked, that's a requirement to make sure that this premises is not a nuisance. We checked, we did not find any nuisance, unresolved nuisance matters. We checked for calls for service with the police department. We didn't find any, which is good. That's excellent. And we did check to make sure that all parties or members of the LLC had satisfied their requirements for their taxes, which is excellent.
Awesome.
No one has appeared in opposition to your license. No one has submitted any documentation. The application was filed on February the 22nd, 2024, with one person as being the 100% owner, and Ms. Cassandra is the managing officer that will oversee the day-to-day operations of the premise. What I want to do is I want to enter on the record a certified copy. This is the liquor code that gives us the right to conduct this hearing today, and it's ordinance 71819. Also, I want to, that's Excise Exhibit 1, Excise Exhibit 2 is the file belonging to Lemonade LLC. Based up on no protest being issued, the applicants signed an acknowledgement form, which is Excise Exhibit 3, that they understand that they will be a restaurant. Your hours of operation will be from 9 a.m. to midnight, nightly or daily. And you understand that you must provide food while your business is open. And what I'm going to do is based upon this being a restaurant, no persons speaking in opposition. All the other issues have been met today. We find no reason that this license should not be approved. Also, we check to see, to be sure that it would not be detrimental to the neighborhood. One of the things that we have to consider is factors to be considered if it would be detrimental. We did not find that here today. Based up on the application being filed that you would be a restaurant, I hereby approve the 90-day temporary license. This is the initial temporary license for the small business criteria. First 90 days you will operate. You bring in your figures, we'll issue a second 90-day temporary, provided we're working on that. After 180 days, we'll be able to go to a final determination hearing and at that time. So do you have any questions right now?
I do. So we do the temporary 90 and a second one, and then goes to a yearly? Or-
It will go to a year. What we have to do is, it's called a final determination hearing. What we do with your two 90-day license, we look at your figures for a projection because it's supposed to be 51% of your food sales. We look for those 51% food sales and or $200,000 in gross sales. So we will review your figures. We'll conduct an inspection to make sure we're operating as a restaurant.
Okay.
We will monitor the hours of operation, ensuring that you're closing by midnight.
Right.
And then we'll schedule a final determination hearing. And then once that is scheduled and approved, then you'll be on an annual license there.
Perfect.
Okay? Do you have any additional questions?
That sounds good.
It sounds good? Awesome. Well, at this time, welcome to the city of St. Louis. Welcome your business to the city of St. Louis, and thank you for doing business. Your 90-day temporary license is hereby approved.
Thank you.
Thank you.
Thank you very
Conclude
much.
this hearing at this time. I'm gonna just go ahead on the record up. If you all wanna ask questions, I'll allow you to ask questions, but we're gonna just do the standard procedure. You're Tim
Yes.
Barbieri.
Yes, correct.
Okay, I'm gonna go ahead and wrap this, take our time here. It is approximately 10:06 a.m. on March the 13th, 2025. We're here today for the application hearing for RGR Holdings LLC, doing business as the Breakfast Corner, located at 5313 Hampton Avenue. This hearing is being requested under Board Bill 64, a restaurant bar at this location. Mr. Miles McDonald is out at this time, so I'm gonna do this. On, and I just wanna catch my notes here. A liquor license, protest was taken out against the issuance of the Restaurant Bois license for this location. At which time the signatures were submitted and that they were found to be a valid protest. Based upon protesting a liquor license, the protesters would need 10 signatures of property owners within the radius or 10 signatures of registered voters, occupants within the radius. Based upon our finding, it was that the protest representative submitted 12 signatures of property owners within the radius regarding your location being issued a liquor license. And based upon the 10 signatures being submitted and authenticated, an official protest has been deemed, at which time both parties have 30 days to mediate and or obtain two simple majorities. Initially, under Board Bill 60, the applicant did not need to obtain signatures. However, once the license becomes protested, the burden of proof switches back to the applicant, in which the applicant has to obtain two simple majority of signatures in order to be successful for an application. Do you have any questions, Mr. Chen?
No, but yeah, we got I'm sorry.
Mr. Joe Kelly for the record.
A couple of questions. One, in the last couple of weeks, they've talked to some people in the neighborhood. They're under the impression that a few people were going to withdraw their signatures from the protest, a letter of protest. Apparently that hasn't happened, or you guys haven't received
No,
anything?
sir, not
Okay.
as of, no signatures on 3-4. We did receive a request to withdraw the summer garden application.
Right, yeah.
No other
Yeah.
neighborhood property owner has
Okay.
withdrawn any signatures from the liquor license letters of protest.
Sure, okay. From this point forward, yeah, we understand that now you'll issue the petition packet to the applicant. What, in a hypothetical situation, what if people had either signed the initial letter of protest or the protest representative, hypothetically, if they withdraw the protest after today, does that have any impact on how we move forward?
Well, we will go to the 30-day cutoff, at which time, if those signatures have been withdrawn, we will, after the 30-day cutoff, we will establish a hearing and move forward at that time,
Sure.
being that the burden of proof has come up on the applicant. We would have to still get two simple majorities.
Okay,
The only, and each person basically would need to remove their name as, being a protest being in opposition to the
Sure.
issuance of the license. Not just one person, it's 10 people,
Right, right.
12 people signed in opposition. So all 12 people would need to remove their name as being in support of or being neutral as far as Board Bill 60. But once it's deemed an official protest, we need two simple majorities.
Right.
Because it was rendered an official protest.
Yes, Jack down.
oh, after the hearing, can we take a look at who's signed?
What can happen after the hearing, you can put a sunshine law request in to obtain any signatures that you need. You would have to put a sunshine law request in.
Okay. The reason I brought this up is the nature of the business is not completely reliant on liquor sales. It's incidental to the use of the business. So what they're considering now, moving forward, in good faith with the neighbors, perhaps withdrawing the application in good faith with the neighborhood, and then perhaps reapplying at a later date, something along those lines, rather than kind of going head to head with something that neighbors are, to say the least, concerned with, something like that. So we'll just have to kind of figure out a game plan moving forward from there. They feel like they have pretty good support from the surrounding neighbors, given the nature of the type of business it is, things of that nature. So we'll kind of figure that out moving forward.
Well, on the record, as per the protest representative, let me just share what they felt that the business did not do. Business is not trustworthy within the community. Property could be a nuisance. Business is very problematic to the community. Parking is not appropriate size for the premises, and the licensee promised to be a business without liquor. So from what I'm reading, they was possibly told that they wasn't gonna have liquor initially, and then they came back and made an application for liquor. That was, the reason why stated by the protest representative that they filed the protest, because the people told them one thing and then went and applied for liquor.
I didn't dispute that anyone even spoke to
What's your name for the record, sir?
Greg
Greg?
Bush.
And I don't know, but I do know that we received some documentation in a literature with a conditional use permit that indicated a young man that I did not see as a part of this license, Mr. Anthony Duncan. Who is he affiliated with your company?
He is the architect.
He's the architect. Now, you told me you was an advisor, so would you tell me what your status is with the LLC?
I'm just here for support of the LLC.
To support it?
Yes.
So, but it's the architect, but Mr. Tim, who is a member, do you know Mr. Anthony Duncan?
Yes, I know he was listed as the architect, yes.
Okay, he's the architect, okay. And based upon the conditional use, because they were saying that you all didn't have an occupancy permit, but on July the 2nd, 2024, a conditional use permit was issued 132359, granted for the address of 5213 Hampton Avenue to operate as a restaurant. And based up on those terms, number one, they indicated about your hours would be 7 a.m. to 2 p.m.
Correct.
Understanding that your liquor license, if you were to apply under Board Bill 60, your hours of operation would be 9 a.m. to 12 midnight. But understanding that you all are requesting, or that the conditional use gave you a reduced hours of 7 to 2. Also, one of the things that was concerning was number 6. It indicated at that time, no liquor, alcohol, or intoxicating beer shall be on the premises at any time. So you all would need to go and do an appeal to the conditional use, because as per this conditional use permit, no liquor could be on that premise at any time. So
Just to
those
clear,
are some concerns that, you all would want to clear up prior to making this application or proceeding with this application. You would want to get those cleared up.
if you don't mind, Gwen, just to kind of clarify conditional use, if you're not familiar with that term, that's when you apply for an occupancy permit and it goes before the zoning administrator. And at that time, there's input from neighborhood, perhaps the alderperson, and the zoning board on the use of the premises. So more than likely, when the architect applied for the building permits, it got routed over to the zoning department. And that's what she's referring to as the conditional use and those conditions on the occupancy permit, which, yeah, those would like,
No, I understand.
Yeah,
completely
okay,
exactly
sure.
what you meant, but
okay,
At
sorry,
the time, I understand why I think they held off because of the new law. that was
Sure.
Coming into play.
yeah.
So that's
Okay.
my understanding why. Okay.
Okay, well, at this time, based upon our office validating an official protest with the protesters of that neighborhood, what I want to do is I want to have the member of the LLC sign a 30-day cutoff letter. This is your packet in which you are receiving the liquor license approval petition.
Hold on.
Sure.
What will be the process? This is 30 days regardless, am I right?
This
Right.
is a 30-day process, yes.
What if we withdraw? Why?
If we withdraw
Tomorrow.
this, can I go apply again? If this gets turned down, what happens?
Okay, now
Signatures
the
don't
thing
come for
about
30
this
days.
is, you all are making an application, you initially made an application.
Correct.
The community filed an official protest, okay? If you withdraw, then I would personally treat it as being denied for 60 days, because if you're denied for lack of signatures, there's a 60-day window. If it's based upon a protest, there's a 6-month window. So, you know, we don't want to just flip flop. I'd rather you all try to work something out with the
Correct.
community
Right.
instead of, you know, kind of flip flopping here, there. Because if you withdraw today, they may come back as soon as you make your new application and file another protest. So we're right back in the same boat. So I guess, you know, the best thing is to try to resolve it, mediate, meet with them, talk to them, see what you all can do to come to a conclusion.
So if we don't withdraw for 30 days, signatures aren't obtained in 6 months.
No. Say that one more time.
If after 30 days, we do not have signatures.
If you don't have signatures, then you fail to meet 2 simple majorities,
Right.
and then it's gonna be denied. Then that's a 60-day. Once a liquor
60 days.
license is denied, it's a 60-day window.
Okay.
That's
If
my
it's
question.
denied on a protest, it's a 6-month window.
So which would this be?
That would, right now, you're trying to get signatures. You may get your simple majority if you're mediating, if you're talking to the community. Some people may change their mind and be in support. So
Understood.
this is what you're trying to do. You're trying to work within the community in which you want to do business to see if the neighborhood will support you. And so that is just that period, instead of just saying you failed to meet the burden of proof, because you didn't have a burden initially, but the protesters gave you a burden by obtaining 10 signatures.
I have a question. Now, what if the 10 signatures there say, everything's good, we worked it out, do we still have to have the signatures?
Well, that right there, and that normally is not the case, but okay, if that is the 10 signatures where you worked it out, it has to be totally a consensus of all parties in agreement that there's no longer a protest. They'll file something that is no longer a protest. We'll meet back here for, it will be and this is an unusual predicament, that we would have to come back to ensure that each person signed that it's in opposition. And in support of your license now. Then we'll move from
So
there.
we still need the majorities.
Yeah, basically right now, because they deemed it an official protest.
Okay, but my question originally was, if everyone on that list, all 12 signatures say no,
Still need it.
do we still need? our
Based upon the
51%
rules and
signatures?
regulations, currently, the rules and regulations, you would need 2 simple majorities.
So regardless, we
Still
need.
need those no matter what.
Currently, yes.
I would suggest, I mean, since we're here, the next step in the process is to get the protest or get the petitions in support. We can then talk a little bit more about it after she concludes the hearing on which avenue, if you want to pursue the petitions or withdraw the application and work things out with these folks and reapply. But I think that's key, is either way, to work things out with these folks. Because like when the supervisor, I'm sorry,
You okay?
was saying, like, you don't want to get right back in, the same boat. We don't want to be sitting here. We
That's the
don't want,
last thing we want.
yeah, we don't want to withdraw the application, reapply, be right back in the same
And that's what
situation.
it's-
I was just trying to see if
Yeah,
there was a quicker process, if we withdrew and applied
right,
with the agreement, we talked to all these people and said, we're not gonna protest it. The
right.
Procedure still is 60 days with you. That's why I was curious to see what is the fastest means of getting this accomplished. If they withdraw 100% of their signatures,
Would it
we
be easier
still
for
have
us
to
just to
get
withdraw
our
and then start it over?
Because
Right,
they gave you a burden, they made you all get a burden, you all didn't have a burden of proof under the small
I
business
guess so my
criteria.
question was, if they said that and we withdrew this, started a new process, but then that wouldn't be the majority anymore, it would just be the hearing.
Yeah, it would just be the hearing, but then they said, well, you know what, we want to protest
Well,
it.
it could.
So we're right back
Assuming we
at
had
the
something that-
same issue, so we need to get it resolved within the community.
understood.
Okay,
so wiping the slate clean would kind of
Still take a
alleviate-
long time.
it would, probably take just as long to go either way from this point forward, is you got 30 days to solicit signatures, turn them back in. They then have to conduct an investigation, will take a few weeks to say, at least to conduct their investigation. And then they have a time period with to schedule the next hearing. So 30 days to get the signatures doesn't mean we're gonna be sitting here in 30 days,
No, we
probably
don't know.
another 30 days after that. So withdrawing it today, working things out, going and reapplying, we're looking at,
At the same time.
about the same amount of time. Time-wise, it's the same thing. And I think, well, we can talk about this after the hearing, kind of personal opinions, and we talk about what the temperature of the neighborhood is, kind of thing.
Okay, moving forward, I need you to sign that 30-day cutoff letter. It's just the cutoff it's not admitting anything. It's just an informational package. It's giving you the approval petitions, a copy of the voter registration within the community, a copy of the business list within the community, as well as the radius in which you would be required to obtain signatures of property owners. Okay?
Yeah, I go ahead and might as well get that while we're here.
Okay, I'm gonna go ahead and indicate that the 30-day cutoff package is being given to the shareholder that's here today. And the 30-day cutoff package that all signatures both for and against the 30-day cutoff are due back here in this office by April the 13th, 2025 at 3:30 p.m. At this time, I'm gonna go ahead and conclude this hearing.
Thank you very much.
Thank you.